Did medieval women walk through life without a whisper of legal standing? Were they simply silent possessions owned and traded like goods? Did a single accusation of witchcraft mean an instant fiery death for any woman across 1,000 years? Did women only ever stay hidden in their homes, never seeing the outside world, never contributing beyond the household? Was every woman always seen as less capable, less smart, less able to think clearly under the law? The truth about women in medieval law, from roughly 500 CE to 1500 CE, is far more complex than the stories often told. Number 5. The myth of the subservient wife and her lost identity. Many people believe that once a woman married in the Middle Ages, she completely vanished in the eyes of the law, becoming nothing more than an extension of her husband. This idea, known as coverture, suggested that a married woman's legal identity was entirely subsumed by her husband's, meaning she could not own property, make contracts, or sue or be sued in her own name. While coverture was a significant legal concept, its application was far from absolute, and its impact on women's lives was nuanced and often varied wildly from place to place and time to time. Medieval legal systems, a patchwork of Roman law, customary law, canon law, and local statutes, rarely presented a perfectly unified front. Consider the concept of dower. In many parts of medieval Europe, particularly in England, a woman was legally entitled to a portion of her husband's land upon his death. This dower was typically 1/3 of his freehold land, and it was hers for life. This was not a gift from her husband or his family, it was a right established by law, often from the moment of marriage. A husband could not legally sell or dispose of land that was subject to his wife's dower claim without her consent. If he tried to do so, the transaction could be challenged and overturned after his death by his widow. Records from the Court of Common Pleas in 13th century England show numerous cases where widows successfully sued to reclaim their dower lands, asserting their legal right against heirs or new purchasers. For example, the plea rolls for the year 1220 include the case of Edith, widow of Thomas de Percy, who brought a writ of dower against her son, successfully securing her legal portion of the family estate in Yorkshire. This legal protection meant that a widow, even one whose husband had tried to disinherit her or misuse their shared property, still had a guaranteed means of support and a significant landholding that she could manage and profit from for the rest of her life. Beyond dower, jointure offered another avenue for married women to hold property. Jointure was a legal arrangement often made at the time of marriage, where specific land was settled upon the couple jointly, with the understanding that the wife would inherit it outright upon her husband's death, often in lieu of dower. This form of property holding provided a clearer and sometimes more substantial inheritance for the widow, ensuring her financial stability. The Cartulary of Battle Abbey, a collection of monastic charters from Sussex, England, contains records from the 14th century detailing jointure settlements for women marrying into local gentry families, indicating precise parcels of land designated for their exclusive use after their husbands' deaths. These arrangements required careful legal drafting and were legally binding, demonstrating that a woman's future economic security was a serious consideration within medieval legal frameworks, not just a matter of familial generosity. Furthermore, within urban centers, certain customs gave married women more economic autonomy than the strict interpretation of coverture might suggest. The custom of fine sole merchant, prevalent in some English towns like London, Bristol, and York, allowed married women who independently traded goods to conduct business as if they were single women. This meant they could buy and sell, incur debts, and even be sued in their own name without their husbands being liable for their business dealings. This legal recognition of a married woman's separate economic identity was vital for the thriving urban economies of the Middle Ages. The records of the London mayoral court from the late 14th century contain numerous entries detailing women such as Alice Wade, a mercer, who appeared in court to pursue debts owed to her business or to defend herself against claims, all without her husband present or legally responsible for her actions. This custom acknowledged that a married woman could, and often did, operate as an independent economic agent, separate from her husband's legal persona. Even in cases where a husband acted as his wife's legal representative, this did not always mean her identity was entirely lost. In property transactions involving a wife's inherited land, her consent was often legally required. Charters for land sales and grants frequently include the explicit statement that the wife, often named, agreed to the transaction, sometimes even placing her seal alongside her husband's. This legal formality, even if sometimes a mere rubber stamp, acknowledges her distinct interest and a degree of agency in matters concerning her ancestral property. The rolls of the assizes from various English counties in the 13th century show instances where land transfers were challenged because the wife's consent had not been properly obtained or recorded, leading to the nullification of the sale. This demonstrates that her consent was not an optional courtesy, but a necessary legal component for the legitimate transfer of certain types of property. The concept of a woman being under the rod of her husband, a metaphor for absolute male authority, also saw practical limits. While domestic violence was not unheard of and was often legally tolerated, medieval law was not entirely silent on extreme cases. Some legal codes, such as the Saxonspiegel, a prominent German law book from the 13th century, specified conditions under which a woman could seek separation or legal protection from an abusive husband, particularly if his violence threatened her life. Although such provisions were rare and difficult to enforce, their very existence suggests that the complete legal subsumption of a wife did not always equate to a total lack of legal recourse or identity in the face of grave harm. Furthermore, within the aristocratic class, women often maintained significant roles in managing estates when their husbands were away on crusades, at court, or engaged in warfare. They acted as stewards, collected rents, oversaw tenants, and managed household finances, often with explicit legal authority granted by their husbands or implied by their position. Letters and household accounts from noble families across medieval Europe, such as those of Eleanor of Aquitaine or Joan of Navarre, document women acting as capable administrators and financial managers, dealing with complex legal and economic matters on behalf of their absent spouses. Their actions, though often under their husband's ultimate authority, still required legal acumen and a practical understanding of property and contractual law, asserting a form of legal identity through their delegated responsibilities. The reality of medieval law regarding married women was a patchwork of customs, specific regional laws, and evolving legal doctrines. While the theoretical framework of coverture was influential, its practical application was often tempered by traditions of dower, specific urban customs, and the pragmatic needs of society, allowing many married women to retain significant economic agency and a legal presence that extended beyond merely being their husband's property. Number 4. The myth of the universally powerless and excluded woman. Many historical narratives paint a picture of medieval women as universally powerless, confined to the private sphere, with no role in public life, trade, or governance. This widespread belief suggests that women were entirely excluded from positions of authority, economic participation, and even skilled labor. However, a deeper look into the historical record reveals a different story, one where women often held significant roles in a variety of sectors, exercising power and influence in ways that defy this simplistic portrayal. In the realm of crafts and trades, women were not merely confined to domestic chores or unskilled labor. They were active participants in guilds, which were powerful organizations regulating specific crafts and professions in medieval towns. Women worked alongside men, often as skilled artisans, and in some cases ran their own workshops. Records from Parisian guilds in the 13th and 14th centuries, such as those detailed in the Livre des Métiers Book of Trades compiled by Etienne Boileau, explicitly mention women as members of guilds like silkworkers, embroiderers, and brewers. These records indicate that women could apprentice, become master craftswomen, and even employ other workers. For example, the silk weaving industry in Paris was largely dominated by women who managed their own businesses, negotiated prices, and trained new apprentices. Their involvement was not peripheral, but central to the functioning of these key urban industries. Beyond crafts, women were crucial to the everyday commerce of medieval towns. They ran inns, taverns, and bakeries. They were often engaged in retail trade, selling everything from cloth and spices to vegetables and poultry in urban markets. The market regulations and court records from towns like Bruges, Florence, and London consistently show women as active vendors, sometimes even dominating specific market sectors. The tax records from the city of Norwich in the late 13th century list numerous women as taxpayers, indicating they were property owners and active participants in the local economy, deriving income from their various businesses. These women were not just assisting their husbands. Many were widows or single women operating independently, managing complex financial transactions and navigating legal disputes that arose from their commercial activities. In the agricultural sector, which was the backbone of the medieval economy, women played an indispensable role. They worked in the fields, participating in planting, harvesting, and threshing. They managed livestock, processed agricultural products, and ran dairy operations. Manorial court rolls from across England, such as those for the manor of Wakefield in Yorkshire, repeatedly document women as tenants, holding land, paying rents, and sometimes even appearing in court to settle disputes related to their holdings. These records show women as active managers of small farms, making crucial decisions about their livelihoods, often independently of male relatives, especially if they were widows. The economic viability of many rural households depended directly on the labor and management skills of women. The church also offered avenues for women to wield significant power and influence. Abbesses, the heads of wealthy and influential nunneries, held positions of immense authority. They managed large estates, administered justice within their ecclesiastical territories, commanded significant financial resources, and often advised powerful secular rulers. Abbesses of houses like Barking Abbey in England or Quedlinburg Abbey in Germany were major feudal landowners, sometimes holding courts, collecting taxes, and even providing knights for military service to the crown. Their legal and administrative responsibilities were extensive, akin to those of bishops or powerful male abbots, demonstrating that women could operate at the highest levels of medieval institutional power. Hildegard of Bingen, a 12th century abbess, composer, philosopher, and visionary, corresponded with emperors and popes, offering counsel and asserting her spiritual authority, a clear demonstration of female influence on the grandest scale. Even within the highest echelons of secular power, women occasionally reigned in their own right or acted as powerful regents for minor sons. The queens regnant, such as Isabella I of Castile or Margaret I of Denmark, exercised direct political and military authority over their realms, making laws, leading armies, and negotiating treaties. Regent queens like Blanche of Castile, mother of Louis IX of France, effectively governed kingdoms for extended periods, skillfully navigating complex political landscapes and facing down rebellions. Their authority was not merely symbolic, it was practical and legally recognized, even if often subject to patriarchal challenges. These women were not mere figureheads, they were active rulers who shaped the course of their nations through their political acumen and legal authority. The idea that medieval women were universally excluded from the public sphere, trade, and positions of power overlooks a vast amount of evidence from diverse regions and social classes. While legal restrictions and societal expectations certainly existed, women consistently found ways to assert their agency, participate economically, and wield influence in ways that shaped the daily life and broader trajectory of medieval society. Number 3, the myth of widespread, instantaneous burning for witchcraft. The image of women being summarily accused of witchcraft and immediately burned at the stake is deeply ingrained in popular culture. This dramatic portrayal, however, simplifies a complex historical reality and often misrepresents the legal processes, penalties, and even the historical period during which the most intense witch hunts occurred. The actual legal landscape for witchcraft accusations in medieval Europe was far more intricate and less uniformly brutal than often depicted, particularly in the core medieval period. Firstly, the peak of witchcraft trials and executions did not occur during what is typically defined as the Middle Ages, roughly 500 CE to 1500 CE. The most intense period of witch hunting, often referred to as the Burning Times, primarily took place in the early modern period, roughly from the late 15th century through the mid-18th century, with significant peaks in the 16th and 17th centuries. While isolated cases of magic and sorcery were prosecuted in the medieval period, they were generally handled differently. Medieval law, both secular and ecclesiastical, often viewed harmful magic as a form of heresy or a lesser criminal offense like poisoning or fraud, rather than a widespread satanic conspiracy requiring mass extermination. For example, Pope Gregory VII in the late 11th century condemned witch hunting as a pagan superstition, urging against it. Legal texts from the 12th and 13th centuries, such as the Decretum Gratiani, a foundational canon law text, treated belief in witches who could fly or transform as erroneous, a delusion rather than a reality to be punished with death. When accusations of sorcery or harmful magic did arise in the medieval period, the legal procedures were often structured and required evidence, albeit sometimes highly questionable evidence in later periods. In England, for instance, the common law did not recognize witchcraft as a capital offense until 1542, well after the medieval period ended. Before that, charges related to magical practices might fall under existing laws against fraud, defamation, or treason if the magic was directed against the king. The penalties were often fines, imprisonment, or public penance, not immediate execution. The case of Eleanor Cobham, Duchess of Gloucester, in 1441 is often cited. She was accused of necromancy and treasonable sorcery against King Henry VI. Her punishment involved public penance, imprisonment for life, and her accomplices faced various penalties, including one being hanged, drawn, and quartered for treason. Her own punishment, while severe, was not burning for witchcraft per se. Even when the death penalty was applied for perceived magical offenses, burning was not the universal method. In many regions, the standard punishment for capital crimes, including serious heresy or treason, was hanging, beheading, or drowning. Burning was typically reserved for crimes considered particularly heinous or religiously offensive, such as heresy, apostasy, or sometimes treason against the monarch or god. In England, convicted witches, once witchcraft became a capital crime in the early modern period, were most commonly hanged. In Germanic lands, beheading was common. In areas influenced by the Holy Roman Empire, such as parts of Germany and Switzerland, burning was indeed used for heresy and witchcraft, but often after extensive legal processes, including torture to extract confessions and under specific legal codes. The use of torture and the specific application of burning were not uniform across all medieval territories or even all medieval periods. The role of the Inquisition is also often misunderstood. While the Papal Inquisition did prosecute heresy vigorously from the 13th century onwards, its focus was primarily on theological dissent rather than folk magic. While some inquisitors later became involved in witchcraft accusations, especially in the late 15th century, with the publication of texts like the Malleus Maleficarum, the Hammer of Witches, which fueled the idea of a widespread satanic conspiracy, the Inquisition's direct involvement in mass witch trials was more limited compared to secular courts. When the Inquisition did find people guilty of heresy, the typical punishment was imprisonment or penance, and the execution of heretics was always carried out by the secular arm, not by the church itself. For a person to be handed over to secular authorities for execution, they had to be an unrepentant heretic, and burning was the standard penalty for that specific crime. Furthermore, the legal systems in place, however flawed they might appear today, often demanded some form of accusation, investigation, and trial. While evidence could be circumstantial based on rumors or extracted under torture, especially later, it was not an arbitrary accusation leading to immediate execution. Courts would typically hear testimonies, examine evidence, and follow certain procedures, however distorted. The Constitutio Criminalis Carolina 1532, a legal code of the Holy Roman Empire, while later than the pure medieval period, illustrates this trend by establishing procedures for criminal trials, including those for witchcraft, requiring confessions, which were often obtained through torture. This system, though brutal, was still a legal process with steps, not an immediate mob execution. The narrative of instant burning for witchcraft also ignores the fact that accusations were not always aimed at women. While women were disproportionately targeted during the peak of the witch hunts, men were also accused and executed, sometimes in significant numbers. The focus solely on women being burned simplifies the gender dynamics and the broader societal anxieties that fueled these persecutions. The myth of widespread instantaneous burning for witchcraft obscures the complex legal realities, the chronological nuances, and the varied geographical practices surrounding magic accusations in medieval Europe. The most intense witch hunts occurred later than the commonly defined Middle Ages, involved structured, albeit often cruel, legal processes, and employed various forms of execution, not exclusively burning. Number 2, the myth that women had no property rights. A common misconception about medieval law is that women, whether single or married, had absolutely no rights to own, inherit, or control property. This idea suggests that all wealth and land always passed through male lines, and that women were entirely dependent on male relatives for their economic survival and legal standing. This view, however, overlooks the varied and often robust property rights that women possessed and exercised across different social classes and regions throughout the medieval period. One of the most fundamental property rights for medieval women was the right to inherit. While primogeniture, the system where the eldest son inherits all the land, was common, especially for noble estates in some regions, it was far from universal. Many customary laws, particularly those governing smaller landholdings or non-noble families, allowed for partible inheritance where land was divided among all children, including daughters. In England, for example, the custom of borough, English, or Gallican meant that either the youngest son or all sons and daughters could inherit land equally. Records from manorial courts across England, such as those of the Abbey of Bec estates in the 13th century, regularly show daughters inheriting land alongside or even in the absence of sons. If a man died without any sons, his daughters would typically inherit his land as co-heiresses, dividing it among themselves. Each daughter would then hold her portion of the inheritance legally, and her husband would manage it in her right, but not as his sole property. Even under primogeniture, daughters were not entirely disinherited. If there were no male heirs, daughters became heiresses, often bringing significant wealth and land into their marriages, which further elevated the status of their husbands. The legal terms of these inheritances were often complex, designed to ensure the heiress's lineage and claims were protected. For instance, the marriage of Eleanor of Aquitaine to Louis VII of France, and later to Henry II of England, brought the vast Duchy of Aquitaine under the control of these kings, but it was Eleanor's inherent right and legal status as Duchess that made this possible. Her legal identity as a territorial ruler remained, even if the practical administration shifted to her husband. For widows, property rights were particularly strong. As discussed, dower rights ensured a widow received a life interest in a portion of her deceased husband's land, typically one-third. This dower land was legally hers to manage, profit from, and even sue for if contested. She could lease it, collect rents, and in some cases even sell timber or mining rights from it, all without needing permission from her late husband's heirs or new lord. The plea rolls of the Court of King's Bench from the 14th century show numerous cases where widows brought actions to defend their dower against challenges from their stepsons or other relatives, asserting their legal ownership and right to possession. These actions were not trivial. They often involved substantial landholdings crucial for the widow's economic independence. Beyond dower, women also held their own personal property, known as movables, which included clothing, jewelry, household goods, and money. While married women's movables were generally considered to be under their husband's control, subject to coverture, single women and widows had full control over their own movable property. They could buy, sell, exchange, and bequeath these items freely. Wills from medieval England and France frequently show women making detailed bequests of their personal property, distributing it among family members, friends, and charities, demonstrating their autonomous control over these assets. The Register of Wills from the Prerogative Court of Canterbury, from the late 14th century, documents numerous wills made by women, single and widowed, detailing their extensive personal possessions and how they wished them to be distributed. In urban areas, women were particularly active in property ownership and management. They bought and sold houses, shops, and urban plots. Guild records and town charters frequently list women as property owners, paying taxes, and participating in urban life through their economic activities. The custom of feme sole merchant mentioned earlier further enabled married women in certain towns to own and manage business property independently, separate from their husband's assets. Court records from medieval Italian city-states like Florence and Siena show women, including married women, engaging in complex commercial transactions, including loans, partnerships, and property deals, indicating their legal capacity to manage significant assets. Nuns, too, had specific property rights within their religious orders. As members of a corporate body, they contributed to and benefited from the communal property of their convents, which could be extensive. Abbesses, as heads of these convents, managed vast estates, sometimes holding feudal rights, collecting rents, and administering justice over their lands, exercising property control on a grand scale. Their legal authority over these properties was comparable to that of a male abbot or a secular lord. The nuanced reality of medieval law shows that women were not universally dispossessed of property rights. While their rights often differed from those of men and varied by region, social class, and marital status, women consistently held and exercised significant control over various forms of property, forming a crucial part of the medieval economic and legal landscape. Number 1. The myth that women could not go to court or represent themselves. Many popular historical accounts suggest that medieval women were entirely excluded from the legal system, unable to bring lawsuits, defend themselves, or even appear in court without a male guardian or representative. This image portrays women as legally mute, having no voice or agency in the judicial process. However, medieval court records across various jurisdictions reveal that women were frequent and active participants in legal proceedings, initiating lawsuits, defending themselves, and sometimes even acting as legal representatives for others. In England, women regularly appeared in local courts, such as manorial courts and borough courts, which handled everyday disputes over land, debt, trespass, and petty crimes. And manorial court rolls from diverse English counties spanning the 13th to 15th centuries are filled with entries of women appearing in person. They brought actions against neighbors for encroaching on their land, sued tenants for unpaid rents, prosecuted individuals for assault, and defended themselves against various accusations. For example, the court rolls of the Manor of Harleston in Norfolk from 1300 show Alice, daughter of William, suing John for a debt of 2 shillings, appearing before the court and presenting her case directly. These records consistently demonstrate that women, especially single women and widows, had full legal capacity to participate in these courts as plaintiffs and defendants. Even in higher royal courts, like the Court of Common Pleas or the King's Bench, women were present and active. While a married woman feme covert was typically represented by her husband in matters concerning their shared property, she could still be a party to the lawsuit, and her consent or presence was sometimes required. More importantly, single women and widows regularly brought lawsuits, defended themselves, and pursued their legal rights independently. The heir rolls and plea rolls from the 13th and 14th centuries document numerous cases of women bringing actions for dower, challenging land disseisin, pursuing debt recovery, or defending their property rights against encroachment. For instance, the pleas of the Crown for Lincolnshire in 1202 record a case where a woman named Isabella brought a charge of murder against her husband's killer, demonstrating her right to pursue legal action for serious criminal offenses. Or beyond simply appearing in court, women could also act as attorneys or proctors for others in certain contexts. While it was rare for women to become professional lawyers, there are documented instances of women being granted the right to act as attorneys for their husbands or other family members, particularly when the male party was absent or incapacitated. The Rolls of Parliament in England from the early 15th century contained petitions from women who requested permission to act on behalf of their husbands or sons in legal matters, and these requests were sometimes granted. This indicates that women's legal capacities, though circumscribed in some areas, were recognized as sufficient for them to undertake complex legal representation when necessary. In canon law courts, which dealt with matters of marriage, divorce, legitimacy, wills, and morality, women were particularly prominent. These courts often provided a more accessible forum for women to assert their rights regarding marriage contracts, dowry disputes, or cases of defamation. Women frequently brought cases to these courts to challenge forced marriages, seek annulments, or enforce marital agreements. The registers of bishops' courts in various English dioceses, such as the Register of Archbishop Peckham from the late 13th century, contain extensive records of women testifying, presenting evidence, and initiating legal proceedings in these ecclesiastical courts. Their testimony was considered valid and crucial for the resolution of these cases, highlighting their recognized legal voice. Furthermore, women could serve as witnesses in legal cases. Their testimony was routinely accepted in both secular and ecclesiastical courts, demonstrating that their observations and statements were considered credible and legally relevant. Court records frequently list women among the witnesses called to provide evidence in land disputes, debt cases, or criminal investigations. The assize rolls often note the names of women who provided sworn testimony, indicating their active participation in the fact-finding aspects of legal proceedings. This stands in stark contrast to the idea that women were legally sidelined and unable to contribute to justice. Finally, in special circumstances, women could hold and administer legal offices. Noblewomen, particularly powerful widows or heiresses, often held feudal courts on their own estates, administering justice for their tenants. They appointed stewards, heard cases, and enforced local customs, demonstrating a direct involvement in the administration of justice. The rolls of the honor of Gloucester, held by Isabella de Forres in the 13th century, show her exercising extensive feudal jurisdiction, including presiding over courts, indicating her legal authority in this capacity. While not an everyday occurrence for all women, these examples show that medieval law was not entirely monolithic in its exclusion of women from all legal roles. The historical record plainly shows that medieval women were not silent or invisible within the legal system. They actively participated in various courts, bringing lawsuits, defending their rights, serving as witnesses, and, in specific contexts, even representing others or administering justice, challenging the simplistic notion of their universal legal exclusion.